So we have some big news in the challenge against the ATF's pistol brace rule. Recently, you guys know that the Trump DOJ agreed to drop their Fifth Circuit Court of Appeals case, which was in the mock lawsuit. And recently, the ATF also moved to settle a bunch of other pistol brace challenges. But one of these cases is seeking to move forward to permanently block the ATF from implementing any pistol brace restrictions going forward. Now, this is critical to protect these items if a new administration comes in. So let's break down what is happening in this critical case. Now, real quick before we jump into this video, if you guys want to support the channel, one of the best ways to do that is to simply subscribe to the channel. That, of course, helps the channel to grow, and then also double check to make sure YouTube has not unsubscribed you. They love to do that, especially on 2A channels. And I want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company. They have great supplements, but one of the cool things about them is they're pro-freedom, pro-America, and they support the Second Amendment and what we talk about here on the channel. So if you want to get great supplements, check them out using the links down below. And if you order something $100 or more, you can get free shipping on that order. And also they have a money back guarantee on your order. As I mentioned in the intro, we have some important news in the battle against the ATF and their current restrictions on all brace pistols as SBRs. The Trump DOJ recently stipulated to the Fifth Circuit that they have agreed with the plaintiffs in the mock lawsuit to drop that active appeal on the whole pistol brace case, and they conceded that the prior nationwide vacatur that was issued by Judge O'Connor can go into effect. Recently, other pistol brace lawsuits were also dropped and determined to be moot because of what happened in the mock lawsuit. But now in a third case filed by GOA in the state of Texas, they are asking for the court to not moot their challenge and not dismiss the case. Instead, they point to the ATF's continued enforcement of the pistol brace restrictions. And instead, in this case, they ask the court to issue a permanent injunction which would block the ATF's enforcement of any pistol brace restrictions going forward. This is important because if granted, it would prevent any future administration or any future ATF from going after these braced pistols. Now, you may recall that the ATF recently suffered multiple losses in a variety of pistol brace cases. Not only did they have multiple preliminary injunctions issued against them, but also they had Judge O'Connor issue a final merits decision, striking down the pistol brace rule nationwide with a nationwide vacatur of that rule. And in response, the then Biden ATF decided to appeal to the Fifth Circuit. There was a temporary abeyance in that case while the Trump DOJ was taking control of the case, and essentially they were trying to determine how did they want to handle this issue. Now, in response, the Trump DOJ eventually decided to pull the appeal at the Fifth Circuit level and concede the mock case in favor of the plaintiffs. So in the mock challenge, the ATF agreed that Judge O'Connor's prior nationwide vacatur of the rule will now go into full effect and that the ATF will recognize and concede that issue. That was the first domino that fell in regards to pistol braces, but there were other lawsuits still pending. You had other lawsuits in the Fifth Circuit like GOA and the SAF cases, and then you also had a FRAC lawsuit in a different circuit court. Now, recently we saw the ATF and SAF send a notice to the court that in light of the mock dismissal, they were also actively moving to resolve their case. The same thing recently happened in the FRAC lawsuit, and they also moved to dismiss the case based on the mock challenge and what happened in the Fifth Circuit settlement. Now, one thing that I've been pointing out in these videos is that there is some long game implications to these decisions to agree to drop these challenges. By agreeing with the Trump DOJ to drop the cases, you get an immediate win and you end the pistol brace enforcement under the rule right here and now, but you also lose the opportunity to get a larger, more impactful final merits win in a court of appeals. Remember that the mock case was only ruled on by a district court judge and also was only based on the APA and some administrative procedure issues with regards to how the rule was put together and how it was implemented. If another anti-gun administration goes into office and they decide to take another crack at the pistol brace rule, the only precedent you really have is in a district court in that mock case, and all they really have is an APA procedural violation, and so they can modify the rule or try it once again to try to get a new rule on the books. It also does not prevent the current or future ATF from saying that they can still regulate braced pistols based on the statutory language itself. And now all of this is being brought up by GOA in Texas in their challenge against the ATF in their pistol brace case. Recently, GOA in Texas filed a status report in their case on this whole pistol brace issue, and they argue that their case should not be moot, it should not be dismissed. Instead, the district court here should instead issue a permanent injunction against the ATF's current and future enforcement of any pistol brace restrictions. Now, in this report, GOA in Texas state that this court ordered a status report on October 24th, 2025, if any party believes this case should not be dismissed, because defendants appear to believe that they are free to continue to enforce the statutory interpretation underlying the final rule, even though the rule has been vacated. Plaintiffs' claims are not moot, and this case should not be dismissed. Rather, the court should enter an injunction permanently preventing defendants from ever enforcing their flawed legal theories against the plaintiffs. They state that in this case, subsequent activities by the defendants raise serious doubts about their willingness to comply with this or any other court's ruling. For starters, the rule was vacated on procedural grounds, not a rejection of defendants' underlying statutory interpretation. And without injunctive relief, defendants are in a position to simulate enforcement of the rule merely by referencing to the underlying statutory scheme defining the NFA's registered firearms, which they're talking about SBRs. Thus, without a permanent injunction, the risk to plaintiffs caused by defendants' flawed legal theories actually remains. They then point out that there have been multiple situations recently where the ATF has tried to enforce the pistol brace restrictions under the underlying statutory language. So instead of pointing to the rule, they say, well, we can do this under the statutory language of the NFA. They state that, for example, in U.S. versus Taranto, the individual was charged with having an unregistered SBR because he had a braced pistol CZ Scorpion. And they also point out how GOA got some emails from some of their members where the ATF claimed that the federal statutory law still requires that braced pistols be registered with them as SBRs. They point out that, as defendants candidly acknowledge, ATF's enforcement of the statute will necessarily incorporate factors like those discussed in the rule. Again, the rule has been enjoined, stayed, and even vacated by numerous courts. But defendants believe that since the rule was vacated on procedural grounds and no court has held that the rule is an incorrect interpretation of the statute, any vacature has no real effect. Rather, defendants' interpretation of the statute can move forward unimpeded as if the rule was still in effect. So even though the rule has been vacated, they state that the plaintiffs have not received all the relief they sought, and certainly not of the relief they need to be protected against the defendants, the ATF, and their flawed reading of the statute. So until the defendants wash their hands of the statutory interpretation underlying the rule, and until they are enjoined from enforcing their flawed interpretation of the statute against the plaintiffs, the show must go on. To that end, they state, plaintiffs intend to seek leave of court to conduct limited discovery on defendants' continued enforcement of their underlying legal theories, and therefore file a renewed request for a permanent injunction for relief. So this is good news for the future protection of braced pistols. GOA and the state of Texas are moving to get a permanent injunction against the statutory interpretation of the NFA trying to treat braced pistols as SBRs, which this would protect, people currently if the ATF tries to go after you under the statutory interpretation, but also potentially protect people going forward so that maybe a new rule cannot be put in place, but also so that maybe a future administration could not just simply try to go after braced pistols based on saying, well, the NFA's statutory text alone allows us to go after braced pistols as SBRs. So this is good news, and I'm glad to see that GOA and the state of Texas are still trying to move this forward to get a more firm resolution and block of any future implementation of the statutory language against braced pistols. So that's what's currently going on right now in this critical pistol brace challenge. Now we will wait to see how the Trump ATF responds to this, request in this new notice here to the court, and ultimately how the court responds to this request as well. So as we get more information, as it develops, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to, of course, like, comment, and subscribe. Also, you can check out my website, armedscholar.com. Over there, we have a lot for you guys. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.